Good morning, everyone, and welcome to Money Talks. This is Money Talks with Attorney Coral, and I thank you for joining me this week. We are on WNOV Radio, which is 860 AM, 106.5 FM, each and every Thursday morning from 11 a.m. till noon. This wonderful show is sponsored each and every week by Columbia Savings and Loan Association. Columbia Savings and Loan Association is the only Black owned bank in the state of Wisconsin with 100 years of service under our belt. Looking forward to continuing to serve into the for the next 100 years. So special thanks to Columbia for all that you do to support this show and bring us live on the air every week in order to talk about any topics that are related to money. So the past maybe 3 weeks or so, I believe, I was joined by Dr. Mose Fuller. Dr. Fuller is one of the directors on the board of directors for Columbia Savings and Loan Association. A special thank you to Dr. Fuller for coming and being with me on the air. And he drops everything, whatever he's working on, and comes whenever I call and ask him to participate in the show. And he led the discussions on the importance of having a Black bank in the community, the importance of community banking in general, but specifically having a Black bank. So thank you so much, Dr. Fuller, for being with me the last few weeks. Um, we're going to shift this morning and talk about estate planning. Most people know that I'm an attorney in Wisconsin, and I have been for a number of years. That in addition to my work with the bank, I maintain a private practice, and we specialize in handling estate plans. So I do like to talk about that every so often to remind everyone that once you have gone to, let's say, a wonderful institution like Columbia, and you have your home and you've got your mortgage and other things that you've worked hard for throughout the course of your life, it is important to see a qualified professional and make sure that you have a good estate plan in place so that we as Black people can get better at um, transitioning our hard earned wealth to our heirs that we intend to transition wealth to, and so that things don't get lost in the process due to lack of planning or lack of forethought in terms of what you would want to have happen with your hard earned assets. So I'm going to take a little time and just talk about that today, and certainly would invite and welcome any input from the listeners. If there's a story that you'd like to tell about your own personal experiences and why it's important to have an estate plan, right off the top, I want to invite you to call in. The number here is 414 444 5250. That is 414 444 5250 or 5253. Now, part of the reason I like to make a point of inviting listeners to call is because I always underscore the fact that I may be a lawyer, but I'm not here to offer legal advice. So there's nothing that I'm saying today or any show that should be construed as legal advice to any one individual. There are certainly rules that guide and govern when and how an attorney-client relationship is formed, and when and how attorneys are permitted to offer advice. So that's not the context of what we're doing here today. What I'm doing here today is sharing information, sharing research, quite honestly, because there's some things that I looked up that I want to talk about today that relate to the notion of estate planning and why it is important. Okay, so let's start off with what is an estate plan. I was going to talk generally about wills, and for the most part, I think people have an understanding of what a will is, but a will can be one component of a well crafted estate plan. So today I want to speak more in general terms of what an estate plan can consist of. And it can consist of a will, it can consist of a trust, it can consist of power of attorney documents, whether it's for your health care or whether the power of attorney documents relate to your finances or business matters, such as real estate transactions, banking transactions, and all of those sorts of things. So estate plan is kind of an overarching title, a description of a plan that could encompass and include all of these different types of documents that would set forth the guidance of how your affairs would be handled in the event of your passing. Okay, so it's a a series of legal documents that describe how you would like your property and other assets to be distributed after your death. Okay, so the person who creates, let's say, for instance, a will or a trust, is that person is referred to as a testator if you are talking about a will. If you're talking about a trust, then that person is referred to as a trustee. The beneficiaries are the people who inherit gifts or other assets by the terms of the documents that you've created. Okay, so what are some of the benefits of a will? Having a will, you can benefit because you're able to decide where your assets go. If you have no will, then the law considers that you have died intestate, right? So intestate means that you've died without a will. And if that's the case, then don't worry. If you live in Wisconsin and you die without a will, the state of Wisconsin will impose a will upon you by statute, right? So the statutes will determine um, who your heirs are, if you have any estate of any size or magnitude, if it's a home, if it's money, whatever it might be. If you die without putting something in place saying who gets what, the state of Wisconsin will step in and decide for you. So it's important to give some consideration to how you would want these things set up. Um, the benefits of having a trust, and this is the main reason in my experience that people consider transferring their assets to um, a revocable trust. And I'm not going to talk about irrevocable trust today because it's its own separate animal, and there's a lot of technicalities that surround that. But for general purposes of today's discussion, sometimes people will choose to put their assets in a revocable trust. And the biggest plus and the main reason from my experience that people do that is in order to avoid the probate process. Um, if you end up in probate, let's say if you only have a will and you don't have a trust and you end up going to probate, well, probate is costly. Probate is time consuming. Probate will require, in most instances, not every, sometimes I see people representing themselves or their estates pro se, not the person whose estate it is, but whoever is considered the personal administrator over the estate can go to court and represent the interests of the estate. But most often people end up retaining counsel because, again, there's technicalities of the law that apply to the handling of these proceedings. And if you're not someone who is legally knowledgeable, then, and even if you are, taking off work and going to court and getting instructions on how to file certain paperwork, it's just not typically the way that it works. Usually people incur the expense of an attorney to handle those things on their behalf. So that's another reason why people tend to prefer to in many instances to create a trust so that the probate process can be avoided. Okay, so those are just some general issues that we've kind of talked about before. I've brought on other experts that have talked in more detail about those matters. So I kind of wanted to keep a more general approach for today's discussion. So I wanted to just kind of talk through some examples of what happens when people don't do estate planning and then you pass away. Um, Everyone knows that I am the number one Prince fan. I claim that, and I don't know, people like to challenge me on that title, but that's self designated that I am the number one Prince fan. But one thing that Prince did that I wish he had called me and we could have talked about, but he died without a will. He had no spouse at the time of his death, and he had no children at the time of his death. So his estate passed to his six siblings. Um, Three of them sold their shares to a company that bought the right to Prince's back catalog, which, if anybody knows Prince, that's probably something he wouldn't have wanted to happen. He wouldn't have wanted his hard work to, pass into the hands of a company that bought his catalog. If you know anything about his life story, one of the biggest things that he went through, I believe in the 90s, when he had the word slave written across his face, is because he was fighting for the rights to his catalog. And there were disputes with Warner Brothers, and there was litigation and all sorts of things, which is part of the reason he temporarily changed his name. So there were extraordinary things that excuse me, that Prince did. Sorry, that Prince did himself back in the 90s. Sorry, guys. In order to gain the rights of over his own work. And when he passed away without a will, that work was transferred, the ownership of it, to people who didn't value it the way that he did, because they turned around and just flipped it and sold it back to a corporation. Um, so again, in the interest of protecting what you've worked hard for, it's always advisable to sit with a professional and talk these things through and think about the inevitability of death and what you would really want to see happen with your life's work. um, Prince, his well, we'll never know how he may have allocated his estate had he had a plan in place. He was a person who was very generous in his lifetime, and I want to underscore the fact that he was only 57 years old when he died. So that's, I definitely know that 57 is not so old. It may have sounded old when I was 25, but I know better now. That's not very old. And so sometimes people think of estate planning being, well, that's for the elderly. That's when people get older. That's when you don't need to be concerned in preparing for death. Well, I don't think he was concerned or preparing for death at the young age of 57, but that's when his life happened to end. So the point of emphasizing that is that estate planning is not just for people who are elderly. Um, Estate planning is for anyone that has any, well, I was going to say any um, assets that they want to um, address and say who they'd like to leave things to. But I know when I had my paralegals on the show, one of the things that they pointed out is that they often do power of attorneys for even college kids. So 18-year-olds that are away from home. I think my paralegal Kelly mentioned at one time, she set up a power of attorney for her college age son, and that worked out because she ended up needing to do some transactions on his behalf related to, I can't remember what it was, but maybe like an apartment lease or something like that. But so sometimes even as youngsters, if you are not physically present and you need to offer some authority to a parent or some other trusted person to handle business matters on your behalf, because once you are of age, you need to have something in place if you want someone to be able to sign certain documents for you. So, just something to consider. Um, what are some of the things that you can do to avoid relatives fighting over your estate? Because that's another issue that comes up if you don't have a will. Um, People will often fight over your estate if they don't like the outcome of things. Um, Sometimes siblings end up as enemies, never speaking to one another again, depending upon how big a fight can get over certain assets. And I'm telling you, when I was young in my career, I just hadn't experienced enough yet, and I thought, well, does that really happen? Do siblings really become estranged over things and money. Well, I've been around long enough to say at this point, oh, yes, they do. And I've seen it with people that I've grown up with, that had good relationships as children, as we were all growing up, and now that a lot of us are at that age where we have a lot of us lost our parents, or are doing elder care, such as myself. That's a responsibility and a privilege. That I have at this time. But you can see where the relationships begin to get splintered, and it's sad. It's one thing if it's a little bit removed, if you don't know the people personally, but it's another thing when you see it with people that you've grown up with and you know what the history has been and you know what the relationships used to be like, and you see these relationships burdened, if not flat out severed, as people are entering into, or they're into their adulthood and end up in some sort of dispute over assets that the parents may have had and how those assets were divided upon death. Um, People can sometimes contest an estate. Um, and you're not going to win if the only reason is that you don't like the will, right? There needs to be more substance to it than that. So you look for legal reasons if there's a need to contest an estate, such as the validity of the will, um, whether or not there may have been undue influence on the parent at the time the will was created, or and these all kind of tie in together, the capacity of the testator or the capacity of the person who prepared the will. So that means basically, sometimes people wait until an elder is on their deathbed. I have gotten these calls where they're telling me, well, he can't really see anymore, and he can't really sign his name anymore, and he can't even really speak anymore, but he'll squeeze your hand, and that means yes. So, can we try to put a will together? No, that is not the time. If you wait until a person is incapacitated to the point where they can't sit and look at that attorney and look that attorney in the eye and say to that attorney with a thorough understanding of what they're talking about, this is who I want to leave my assets to. This is how I want to leave my home. I've got X amount of dollars in the bank, or I've got these stocks and bonds, and here's how I would like for these assets to be dispersed, upon my death. A person needs to be able to have the capacity to understand what they're talking about and to communicate that clearly and thoroughly to any attorney that they're asking to put an estate plan in place. But as I said, I've gotten the calls where the person is just hours from death and they want me to try to put some sort of document in place that I can go to court and stand by and say, yes, I believe this person was in their full capacity when they asked me to put this document together. Well, I can't do that if they can't talk to me. And only thing they can say is, well, they'll squeeze your hand and that means yes, or they might be able to make an X, just barely, but if you hold their hand, and all these other things that people try to come up with. And it's just not a best practice. It's a situation where you're basically asking for that will to be challenged. You're asking for that will to be questioned. So it looks like we do have a caller. Caller, thank you. Please go ahead with your statement.
Good morning. I was just calling just to find out because you're all your different statements being made. What primarily is the difference between a will and a trust?
Okay. Yeah, that's a very good question. Um, so when we talk about a will, we're talking about a document where you basically say, this is how I would like my belongings to be left. But a will must go through the process of probate in Wisconsin. So if you have only a will without a trust, the will itself will go before a court after your passing. It will be published in a local newspaper, so that if there's anyone that wants to make a claim against the estate, if anything of that nature, they have an opportunity to appear in court, to contest the will, or to just file a claim against the estate, so that it can be considered once the estate, let's say, is liquidated, so that creditors can be paid from it. If you have a trust, one of the big differences is that a trust is a private document. It does not get published in a local paper such as the Daily Reporter, which is where information concerning wills is published. But a trust is a document that you can create while you are still alive, and you can manage all of your properties and all of your um, assets while you're alive still, through a revocable trust. A revocable trust does not require the probate process, so that distinguishes it from a will and the privacy of the trust. So those are the two biggest differences between those two documents.
Okay, thank you very much.
Thank you. Thank you so much for your question. So I
You're
appreciate you
welcome.
calling in today. Um, so, what can you do to reduce the likelihood of fighting over your estate? I will give you some advice on that, or excuse me, a recommendation on that when we come back from the break. It looks like it's time, but we will be back with more discussions about estates and estate planning when we come back from the break. This is Money Talks with Attorney Coral. Thank you. And we're back. This is Money Talks with Attorney Coral. Thank you so much for rejoining us after the break. Um, right before we went to break, I was asking or raising the question, what can you do to reduce the likelihood of a fight over your estate? And the answer to that is to get good advice. So, um, I wanted to well, you gotta. When I say get good advice, you've got to dot your I's, you got to cross your T's. You have to make sure there's no ambiguity in the documents that are being created. Um, you should create your estate plan while your capacity is good so that it won't be challenged because people think that maybe you were out of it and weren't sure what you were doing or weren't sure what you were signing. Um, and don't ever let it appear that you're being influenced by any one person. You should communicate the blunt truth of what estate plan you're putting in place to your heirs so that things don't come as a shock to people after the time comes when you've passed. So if you're a person who may be looking to just and you're curious or you've got some questions, or if you would like to set up an appointment to talk further about any questions that you might have related to estate planning, please give my office a call. And if you mention that you heard about us from WNOV Radio, you will get a free consultation. um, I'm going to leave the phone number for Angelina, who is my paralegal. Her number is 414-313-6625. Angelina, the paralegal, is 414-313-6625. You can reach her directly at that number. But again, if you would like a free consult, you need to mention WNOV Radio, the Money Talk Show, that you heard about us from WNOV Radio. Okay. If you've got those questions about estate planning. So I'm going to shift gears a little bit again here. And I just want to go back to some of the celebrity examples because I did a little research to see some celebrities who actually died without a will. And I was surprised. Some of them I knew, but some of them were a surprise to me. So, Howard Hughes, you guys know who Howard Hughes was. He was an eccentric billionaire um, who flew airplanes. Didn't he even like build airplanes? He was a brilliant genius of a person who I believe was also an actor, but he was very eccentric and very reclusive during the later half of his life. So he was an unusual individual, but he died in 1976. He was 70 years old. When he was alive, he was a devout Mormon, and his purported will was discovered at the headquarters of the Mormon Church in Salt Lake City. But it was later proven to be a forged document. It went to court and it was established that that will was a forgery. And so he died intestate with no will, and his estate was divided among 22 cousins. Most people, when they're preparing how to transition their life's work, all of the assets and properties or whatnot they may have accumulated in a lifetime, this person who was a billionaire, maybe he would have wanted it divided between 22 cousins, but who knows, right? But that's what ended up happening because he did die without a will. The next one that I wasn't aware of was Abraham Lincoln. Um, Lincoln, as most people know, was also a lawyer. So imagine that. This gentleman who was a president, who was himself a lawyer, failed to prepare a will before he was assassinated in 1865. Now, maybe surely he didn't expect to be assassinated at a relatively young age. But his estate was ultimately split in three equal shares between his wife and his two surviving sons. Um, I've read enough about the life story of Abraham Lincoln to know that his wife, I believe her name was Mary, um, had some pretty severe mental health issues for a portion of her life, where brought on, from what I've read, primarily by grief. She had already lost a son, and that took her over the edge, and then losing her husband in such a brutal way left her a little bit unstable from an emotional standpoint. Um, but again, no will means that the assets held in trust for minor children instead of going to their mother or father. And again, I'm suspecting because of the mental instability that was pretty well known. I think she was even institutionalized at one point after the death of her husband, but he didn't have a will. So the assets had to be held in trust for the two kids until they were of age. Um, Someone that you guys probably know more about than I do, I'm dragging you into this now, Jermaine, is Steve McNair. He was a football player. You remember who he was? He was, according to my research, a Tennessee Titans quarterback, and he well he died very young because his life was cut short. Yeah, Steve McNair, when his girlfriend at the time, um, unfortunately killed him and herself, whatever was the issue, and he was only 36 years old. So he had no will at the time. So intestacy, again, that's what that means. And whatever state he was in or resided in, just as Wisconsin does now, probably imposed a will on whatever assets he had because he was a pretty well known athlete. Am I right? Yeah, because I know that name. Yeah, so he probably had some money, some assets that had to be handled upon his death. Um, Another person, and this really surprised me because I don't know. I mean, you just think um, that people consider this sort of thing, but Sonny Bono, because he had been a politician and for a number of years. But I remember Sonny Bono growing up as a kid because Sonny Bono was married to Cher, and they used to have a variety show. I remember that they would sing one of their hit songs starting and ending the show. But he died in a skiing accident back in 1998, and I remember that. So like it's funny how much time has gone by. That's been what 27 years now, but I remember that. um, and his wife at the time was a woman named Mary, who was appointed the estate's administrator. But his ex-wife Cher made a claim against the estate, and an alleged love child came forward as well. So he had a little bit of confusion going on. Johnny Taylor, maybe not as grand as Johnny Taylor, but Sonny Bono had some drama after his death because there was no will. He did have a wife, but Cher came forward and contested some things, as well as some child that hadn't been acknowledged. So there was some courthouse chaos surrounding his death because of all of that. And so it's important. I mean, I'm not bringing this up to try to um, pass judgment or critique anyone or make anyone sound bad. But it's the point that you end up going to court, and these matters, sorry, sorry guys about my voice today. Um, they end up being litigated in the court system. And that's good for the attorneys. The attorneys generally get paid by the hour. So the longer and bigger the fight, the bigger the bill. And they're able to get paid because these estates are generally worth millions of dollars. But let's say your estate is more modest. Maybe your estate is not worth millions of dollars. Maybe your estate is only worth a couple 100,000, whether it's a property or some sort of asset that you have. Do you really want your heirs to have to spend a year or more in court litigating matters so that the attorneys end up getting paid and your heirs don't? So that's why it's important to consider these things. Um, there's another person that I saw by the name of Stieg Larson. This gentleman was a Swedish author. He authored the book entitled The Girl with the Dragon Tattoo and other books. He died back in 2004. He died without a will, and his estate was distributed pursuant to Swedish intestacy laws. He had a lifelong partner of 32 years. Her name is, or was, I don't know if she's still living, but Eva Gabrielson. I hope I'm pronouncing that right, Gabrielson. Um, and she ended up receiving nothing. So, can you even imagine spending 32 years of your life with a person and they have an estate that's worth millions of dollars and they pass away without a will and you receive absolutely nothing after sharing 32 years of your life with this person? Um, she eventually came to a resolution with his family to grant her ownership of their shared apartment. But no will can equal your loved ones drawing a short straw and ending up with nothing. That's probably not what he intended. You know, we're assuming that 32 years that they had a good relationship and she was there for him, maybe even cared for him when he was sick unto his passing, and she was left in the terrible, weak position of having no legal authority to step in and have anything to say about his money or about his property or anything else. But again, the family was able to take the legal control and they had every right under the law to do so. And but apparently there was some courtesy extended and she was granted ownership of a shared apartment, which at least I guess you can say at least she didn't end up homeless after all of that. But that sounds like the floor to me, rather than the ceiling in terms of how that would work. So I think that's an important point, Jermaine. What are your thoughts on that? If somebody's going to live with the person and let's say common law marriage doesn't apply, and you end up in a situation where you've spent 20, 30, 40 years in relationship with someone and that person passes away, and you can end up in a situation where you have no say over what happens to their estate. Let's say if you were not legally married to that person, a lot of times people think that, oh, common law this, common law that. Well, Wisconsin is one state that doesn't honor any common law marriages, so you can live with somebody as long as you want. In the state of Wisconsin, you still are not declared to be husband and wife as a matter of law. That does not happen in this state. And apparently, it did not happen for these people in Sweden. All right. So another person was Amy Winehouse. Now, you talk about dying young. She was part of, what do they call it? The 27 Club, all these different famous people. I think Jimi Hendrix was one, and there have been other very famous celebrities who all died at the age of 27. Well, that's a club nobody wants to be in, right? But Amy Winehouse, who unfortunately, as brilliantly talented and gifted as she was, had a well known drug problem. And she even sang about it in that Rehab song, which is real catchy, but the reality behind it was devastating. So Amy Winehouse died at the age of 27 of alcohol poisoning. This was back in 2011, and she died without a will. Again, 27. Who's thinking about having a will? Well, her parents ended up being the sole heirs and administrators of her estate. Although there was a documentary called Amy that showed that Amy, according to the documentary at least, had a very contentious relationship with her father. And so the thought is that potentially the contention between them was such that she might not have wanted her father to have inherited half of her estate, but she didn't have a will. So in this case, that equaled, I suspect, unintended beneficiaries. So you're familiar with her story, right, Jermaine? Because she was a talented person and you
Yeah,
know who she was.
yeah. Amy Winehouse, she was a very talented young lady. It's unfortunate she passed away early. Um, But yeah, it's just the importance of having a will in place. That's very, very, very important. So at least when you leave here, your family that's here, they can take the proper steps that everything can go smoothly without arguments and trying to figure out what's what.
Hmm.
It just be a smoother transition for
Right.
everybody that's involved.
No, I totally agree. And I know that I was raising a question a little bit earlier. I know you had to take a call that came in, but I was talking about the importance of people if they're going to spend decades of their life with someone. If you're able, you get married, and don't think that marriage doesn't matter and the contract of marriage doesn't matter, because you can end up with nothing. You have any thoughts on that?
Yeah, that I think that's very important. That if you guys decide to become one, um, and it's until death do us part. Just handling the stuff that needs to be handled before death. So after death, it'll be a smoother transition. But just to be, excuse me, just to be with a person for 20, 30, 40 years and then you end up with nothing is devastating.
Yeah,
That's
yeah.
devastating.
No, absolutely.
Because you
I
mean,
wouldn't want to be listed in the obituary as somebody's special friend.
oh
You know,
yeah, you'd be like, wait a minute,
you
special.
you and
And I've seen
that's
it.
if they put you in there at all.
I've seen it. And
I've
special
seen it
friend
too.
such is like, wow.
Right, right.
Uh,
And maybe even the community, you held yourself out as husband and wife, but if that's not a legal
yeah,
document, then you deal with the consequences of that.
yeah.
Okay, so it looks like it's time to take our next break, and we will be right back with more Money Talks with Attorney Coral. Thanks for listening. Okay, welcome back. We're back with Money Talks with Attorney Coral. Thank you so much for listening. Today we're talking about the importance of estate planning, and Jermaine and I were kind of going through a list of celebrities that I researched that didn't have an estate plan, and I'm shocked by every name on the list. But just to continue in the discussion, we were talking about Amy Winehouse before the break, but now. Um, I'm going to add to the list, and I was aware of this one, the legendary late great Bob Marley, reggae king. I won't even say superstar because he was bigger than that. Marley died of cancer back in 1981, 8 months after he discovered his illness, which started in one of his toes. I mean, it's just a tragic story. You know about that one.
Yeah, hearing the story and seeing the movie,
Mm-hmm.
uh, it was something that was in his shoe,
Right.
and but that's a whole other story. But yeah.
Yeah, a whole other story, but an interesting one.
Mm.
And he was what I believe about 36 years old at the time. He was very young. But he was a worldwide superstar. In part because the music that he created brought people together. You know, it was about unity, it was about love, it was about goodness, it was, anti-war. It was all the things that are good about human nature to bring people together. So he was, just a wonderful, wonderful, um, creative, talented person. Um, but in all that time, the 8 months or so that he found out about this cancer, he probably was in some denial for a good portion of that, I imagine. But under the Jamaican law, his estate, because he did not have a will, so, under the Jamaican law, his estate was divided among his wife, Rita, and 11 children. And that left Rita with only 10% of his assets. So, she was his wife, and he had children with her. But Bob Marley also had children with other women than his wife, but they all were taken into account under the Jamaican law since he died without a will. And so the upshot of that is that the spouse was unable to fully control or manage the family assets. She got about 10% of his assets. And yes, he was a millionaire, but his estate is probably worth a whole lot more now than it even was back in 81 when he passed away. And even though she had been his wife for a number of years, she didn't have control of things after, not full control of things after he passed away. All right. I had mentioned Jimi Hendrix as another person who was part of that 27 club that nobody wants to be in. But Jimi Hendrix did die back in 1970 at the young age of 27. And the fight over his estate lasted over 30 years. Can you believe that? Imagine fighting over an estate for over 30 years. Um, Particularly Jimmy's likeness and his image. In 2015, a settlement was reached prior to trial to determine how much Hendrix Licensing, a company that was run by Jimmy's brother, Leon's business partner, owed to the Hendrix estate for sales of unauthorized merchandise. So basically, um, he was infamous, right? Even in life and certainly in death, and his image was worth millions of dollars. Such so much so that 30 years later, people were still fighting over the money that others made just off of unauthorized merchandise that used his image. Because again, there was no will, and so there was no closing of this estate. The litigation went on and on. Sure, the attorneys got well paid, but how would Jimi Hendrix have liked to have left his estate? Um, Famous actor James Dean. And I've seen movies with him. I can't think of any names of those movies now, but I know that that's a name that people would know. He died in 1955 at the young age of 24. Um, Although he had made only 3 movies at the time, He failed to have a will prepared, and his estate went to his father. Um, Having some uncommon forethought, his father used the money he received in the estate to start a foundation to maximize the commercial value of Dean's name, likeness, and image. It's interesting how popular he was with only three movies. I think that people saw his talent and his capability and his potential. And from what I understand, I think he was considered to have been a handsome um, person. Um, but Dean has been one of the top 10 highest earning deceased celebrities up until 2012. Um, in 2015, his income was $8.5 million, and he's been gone for over 60 years. So imagine you're dead that long and you're making that kind of money and you're still in the top 10 of celebrities. And maybe some of that is because he died young. I know he kind of had that bad boy energy that people liked, and maybe that's why they made such a big fuss over him, even though he had done only three movies. And again, I'm not saying he wasn't talented. I just don't know what those movies were off the top of my head, but I know his name and I know he was someone that was well thought of. 60 years later, $8.5 million. But again, there was no direction about what was to happen with that money. Um, and last but not least, I want to, well, actually, I have a couple more if there's time, but let's see how far I get. But I do want to mention Pablo Picasso. Okay, the famous artist. You guys know who he was. He died in 1973 at the age of 91. And even at that age, Picasso didn't plan ahead. Did he think he was going to live forever? If you're in your 90s and you still don't have a will, I can almost excuse these 24 and 27-year-olds, but if you make it past the 90-year threshold, get some paperwork together. Come on now. You know, his family fought over his estate amid numerous claims, even one by the French government for past due taxes. And if you got those, you know they're coming. Um, his kids ultimately did receive the bulk of his estate, but only after several long fought legal battles. So no will equals family heartache. Okay, so that's the. I hope I've given enough examples. I was going to talk about Aretha Franklin, if I had time, because I thought about her as I'm sitting here, but we'll take that up another time. I would like to thank everyone for listening today and hoping that I've underscored the importance of having a good, solid estate plan. But if you need some help and you would like a free consultation, call 414-313-6625. But you must mention the Money Talk Show to get a free consultation. Thank you, everyone, for listening. And I'll be back next week with more Money Talks with Attorney Coral. Thank